thank you everyone for joining us today for our affirmative action webinar on adverse impact in hires, promotions, and terminations. So we're going to get started with adverse impact analysis. Our first slide, we want to talk about the definition of adverse impact. If you have ever been audited by the OFCCP as a federal contractor, you know that they focus on your applicant tracking. The reason they do that is because they measure your hires versus your applicants, and they are looking to see if you have any indicators of discrimination. So what is adverse impact? U.S. government's uniform guidelines on employee selection procedures define adverse impact as a substantially different rate of selection in hiring, promotion, or other employment decisions such as termination, which works to the disadvantage of members of a race, sex, or ethnic group. So when adverse impact exists in your statistical analysis, what should you do? The first thing you want to do is compare your placement goals. So if your adverse impact is in hiring, compare your placement goal analysis with your adverse impact analysis. So your placement goal tells you if you're short in headcount in a particular protected category. Your adverse impact measures your decisions that you made in that particular protected category. So you want to compare those. For every job group where there is a placement goal, analyze that you hired, promoted, or terminated. You want to make sure you compare that with your adverse impact. Look at your actual selection rate for all your groups, including males and non-minorities, and then be able to defend your selection process in hiring, in promotions, and in terminations. You must be able to back up any adverse impact finding with documentation. So for instance, your hires versus your applicants. You may be able to, maybe requested by an OFCCP compliance officer if you're audited, to submit your applicant tracking log. So they will be checking your applicants, and they will be checking applications and resumes listed on that applicant tracking log. So we're often asked, how long are we supposed to keep our data? Keep your affirmative action plan 3 years and the data that backs it up. That includes those applicants. So you want to make sure you keep the applicant transactions. You can keep them electronically as long as you can produce them if requested. You want to keep track of your disposition reasons. Why did you not hire someone? So that should be on your applicant log. You also, if you have them, keep the phone numbers and emails of your applicants because the OFCCP has been known to want to contact them. Sometimes you have phone numbers on the resumes when we submit them. Usually you have an email address. You want to keep those. For promotions, you may be required to show documentation to back up any adverse impact. So that would be documented paperwork showing persons considered in the promotion pool. Promotion policy or procedure, that is another item that is listed in the OFCCP audit letter, and they request that you have your promotion procedure at least. Some companies don't have a policy behind promotion, but they usually have a procedure. So your procedure needs to be adhered to with consistency, and it needs to be non-discriminatory in its structure. So you don't want to be accused of systemic discrimination because you aren't consistent in your procedure. OFCCP may schedule an on-site audit to interview employees. So you make sure that your documentation can be backed up when if the employee is interviewed. Remember, you can't be present, so your documentation should back up anything the employee says. If there is adverse impact with termination transactions, you would be required to produce exit paperwork, exit interviews, severance agreements. So we've had situations where the documentation or the termination log says, well, this person was terminated because they were laid off. Then they asked for the severance agreement, and then the severance agreement doesn't necessarily, it may be a mutual agreement, or it may say that the person was terminated and there was no severance agreement and it's really not a layoff. And you have to, your data has to match your documents. So you want to be careful of that, be consistent. And you want to have contact information for your terminated employees, including the phone numbers and email addresses. And sometimes they will ask for the physical address if they want to write them and go through the U.S. mail. When there is adverse impact and there is a layoff or RIF, documentations for terminated employees that were given the opportunity to return to work sometimes is requested. And then if you have given an employee or a list of employees the opportunity to return to work, and some of them decline that, sometimes the OFCCP will want the documentation of employees' responses to the request to return to work. The OFCCP often asks for criteria behind a layoff. Why did you select this group of employees to lay off? It is common for companies to select employees that are poor performers, and that is not necessarily the type of criteria that you want to give to an OFCCP compliance officer, because that's not really a layoff, that's termination for cause, because it's performance. So you need to produce your termination criteria when you lay off or have a RIF or a reduction in force. So we're going to take a look at a couple of employee adverse impact analysis examples. This is an example of adverse impact analysis for hires versus offers, and this is July 1st, 2016 through June 30th, 2017. This is our sample company. You can see here that we have these done according to job groups. And then this one, job group 2B, professionals, we have adverse impact, or a indicator of significant disparity pointing towards discrimination. We see that for in this particular case, remember it's hires versus offers, there were 199 male applicants, 25 were hired at a 12% rate of selection. We had 173 female applicants, 3 were hired at a selection rate of 1.73. This is an indicator of systemic, over here it says significant disparity, or it is an indicator of discrimination against females. We also have the same indicator against non-minorities, because non-minorities were selected for hire at a 3% rate, minorities at a 45% rate. So when we're looking at this type of example, we would have to produce all of these resumes for all of these individuals that applied, and then the OFCCP would decide if the company discriminated or not. So they would look for who was the most qualified. So remember, you want to base your decisions on qualifications. So you want to hire according to the qualifications. So is this okay? Well, it depends. These applicant pools are pretty large. What we would want to know is, are all of these applicants qualified? Did we have mixed disposition reasons in here that were incorrect? So this is critical, and we will take a look at this. We're going to look tomorrow in our webinar on applicant tracking. We're going to go heavily into the disposition reasons, but that would be maybe a problem here, and maybe some of these are really not qualified applicants. So we would definitely look into that. Oh, we have another one here. This one we have, these are our operatives. We have 14 males that applied. 5 were selected and hired. 20 females. 0 were selected and hired. So we go back, are all of these qualified? Why were these females not selected? Why were none of them selected and hired? So this is problematic because this is an indicator of significant disparity or points towards discrimination against females. And here's another one here. These are operatives. These are semi-skilled. There's 229 applicants. 12 were selected for females. And at a 5% rate, males, there were 123 applicants and 50 were selected at a 40% selection rate. So this selection rate right here is critical. You see how the non-minorities and minorities are pretty close, so there's no flags here. Down here, American Indians, there were 18 American Indians that applied, 0 were hired. So this is flagging some indicator of discrimination against American Indians. So again, when we go back to our slides, when you have an indicator of discrimination for hires versus applicants, which is what we just looked at, the OFCCP will want to see the applicant log, the applications, and or resume. Some of you are not using paper applications or electronic. They would look at the disposition reasons, and then they would decide for themselves, is the company discriminating, or did they truly hire the most qualified applicant? And then if they feel that they need to talk to the individual applicants, they will ask for their contact information. So the next example we want to take a look at are promotions. This is a similar view. It's a similar looking report. And in this case, we have these looks like professional engineers and design. We had 30 males apply. 9 were hired at a 30% rate. 5 females, 4 were hired at an 80% rate. So in this particular case, and this happens now and again, this is a company that really had very low headcount for female engineers. So they kind of pushed and really did some additional recruiting, and they had 5 qualified female engineers, and they ended up hiring 4 of them. They had a placement goal for females for engineers. But on the other side of the coin, because they hired these females at an 80% rate, it's showing an indicator of discrimination against males. So what they would then have to do is provide all 35 sets of documentation of why were these females promoted and not the males at this percentage. So in this case, they were trying to fill, and they were recruiting, and they brought in females. They brought in some interns, I believe. Then when they did graduate, they hired them. So these were promotions, but at the same time, it is causing an indicator of discrimination against males. The next we want to look at are terminations. And this is a similar looking report. In this case, again, it was 2A, professional engineers and design. So there's 5 females and 2 terminated. Some, maybe they left, or maybe they were discharged. We don't really know on this because we have to combine them. There's an indicator of discrimination against minorities. Why? Because they only had 2 and 1 left. And then over here against Asians, because they only had 1 Asian and that person left. So whenever you have this selection rate right here that is much higher, or it's at a higher rate that causes adverse impact against a protected category, it will flag an indicator of discrimination. The key to this, and this is never good to go into an audit with adverse impact, the key to this is to be able to show your backup documentation. So what it's found, when adverse impact is found in statistical analysis, the compliance officers will then open up the analysis to further investigation. It can lead to exposure of contributing factors that can be interpreted as discrimination. So we want to kind of go into these and take a look deeper into some specific cases that once there is a indicator of adverse impact, then the compliance officers start to dig. So The OFCCP is looking for systemic cases. A systemic case is one that shows a measurable pattern of discrimination based in part on statistical evidence. So they look for patterns. They look for patterns as they go through your adverse impact. They look for patterns in your headcount or your incumbency. They look for patterns in termination, also in compensation. The next is a case that shows a practice applicable to multiple applicants or employees that result in discrimination. So that's kind of what we just looked at in those sample reports. So in a sample selection for hire, a federal contractor allows the OFCCP regulations for job postings and conducts meaningful outreach for minorities, females, disabled, and vets. The applicants selected for hire were all the result of employee referrals. So in this case, there was an applicant log. None of the people that applied through their recruiting means, other than their employee referrals, were hired, which is very improbable. So in this particular case, the compliance officer is going to dig further and want to know where was the job posted, and they would want to see resumes for these other applicants that applied. In this case, the contractor followed the OFCCP regulations for job posting with a staffing agency. So can you do this? A lot of you use staffing agencies? Yes. But let's say you have an agreement with the staffing agency that they will do job postings outside their company. They will reach out to the state employment office. They'll reach out to the disabled. But then the applicants selected for hire are all the result of pre-selected applicants that were payrolled through the agency. All the other applicants were not considered. So this happens often when friends or relatives are payrolled through an agency and the agency is still doing the outreach. If you payroll somebody through an agency, they have to be the most qualified in that group of applicants. So you cannot ignore that other group of applicants. This is a selection for promotion. The selection for promotion based on factors outside of performance. This particular case resulted in only non-minorities being promoted and minorities not considered. So that's why we want you to have a promotion procedure in place so that you don't color outside the lines. You don't use factors outside of performance. Selection for termination applied with inequality is something that you have to really watch for. This can result in minorities being terminated at a higher rate than non-minorities. So what we mean by this is when you select somebody for termination, you need to follow your termination policy with equality. So let's say it's for attendance, you have to follow your steps to the termination policy. So how many times does the policy say they can be tardy or late before they're terminated? And then you apply that with equality. Disparate impact claims have involved selection criteria that are not necessary to the performance of the job, but which instead reflect stereotypical notions about the skills required for the position in question. So remember, we talked about different cases where there are facts behind the termination that do not involve performance. In this case, this can be a physical requirement for lifting or stamina. This can impact gender and disability at a higher rate. So you want to make sure that your requirements for lifting or stamina are job-related and of business necessity. So if it's a clerical position, probably not job-related and of business necessity to be doing heavy lifting. If they're working on a loading dock, then that would be job-related and of business necessity. So it depends on the job, and it must fit the job requirement. The education requirement can result in disparate impact claims. Education requirements must be job-related and of business necessity. So if you have let's say you have a warehouse type position or an operative position, but they do have to do some measurements and they have to be able to measure components. They maybe need to know fractions and they need to know decimals and all of that. So that may be a math test that they need to take. That is job-related and a business necessity. But if it is not, then you should remove that education requirement. Pre-employment testing can be put in place as a policy because it's necessary, but the testing may not be acceptable to all of your jobs. So the test must be given to all persons that are within that particular job title where it is applicable to the job. The test must be job-related and it must be of business necessity. I'm going to talk a little bit about individuals with disabilities. The OFCCP consistently has been giving the audited federal contractors an evaluation of your online application and selection system. They continue to use this questionnaire because they're looking for obstructions for disabled to be considered for open positions. So they will ask these different things. Does the company prominently display a notice of how to obtain reasonable accommodations, including contact and process information? So how do you display a notice? How do you communicate that both to applicants and employees? You do it the self-ID forms. This is one of the ways we suggest. Post a memo with your self-ID for disability and your self-ID for race, gender, and vet status. If an employee wants to change their self-ID status, these notices are posted where an employee can go and read them. Also, if you have an open door policy into your HR department, there are memos and forms that they can request, or you may have an area there where they can pick up memos and forms. But this would be one of them that we would suggest that you post or make available to your employees. Let me go back to this one. The reason we suggest you do it for race, gender, and vet status is sometimes people want to go back and change their status. So if they want to change their status in any area, they can. Now, we all have been experiencing friends or relatives, or even you yourselves, where you run your DNA and you realize you're a different race than you thought you were. So people are changing their race status. They're changing their self-ID status. Gender is one that can be changed through transgender. And then veteran status, sometimes people will change that. That's not exactly one that is common for them to change, but they sometimes will change their status if they feel that it's valuable to the company. For applicants to want to request a reasonable accommodation to apply, OFCCP is checking in to see if you have this language on your career site. So this is language that you can put on there. You put a little symbol here, and that's, it's just a good thing to do. It calls their attention. Basically, this should be on the front of your career site because it's to notify people if they're having trouble applying as a result of their disability or they're a disabled veteran, that they can call someone. So this notice needs to have an email and a phone number attached to it, and it needs to be monitored by someone. If you're a very large company, you're going to need somebody that will monitor that for individuals with disabilities, because if it's on a career website and you're an international company, I'm sure that other countries will be fine with this, but who's going to monitor that phone number and email? And that particular area has been a little bit problematic for some of the larger companies. So the OFCCP is checking into contractor documentation of requests for reasonable accommodation. So you need to also have a log. So if you have a request for a reasonable accommodation, track the employee, their title, their EEO code, the date they made the request, and what was the request for accommodation, and what was the accommodation. So you're not documenting a disability, you're documenting accommodation. And that's important. This also should be documented for religious accommodation. And religious accommodation will usually change an employee's schedule in some way. So you do want to document those. It's always best if the employee requests it in writing. If they don't, doesn't mean it is an accommodation. And you want to have written steps to the interactive process. So this is the individual with a disability or veteran log. So this is, we're giving you this list because we want you to put this in a log. Last, first name, ID, race, sex, job title, EEO code, hire date, disability status, vet status, and then the accommodation requested, accommodation provided, and the date accommodation was provided. The reason we put veteran status is sometimes the individual may be a disabled vet. In your interactive process, this is a common sense communication, just like you would in employee relations, to communicate with the individual so they can express their need for the reasonable accommodation. So the goal, again, is to understand the reasonable accommodation, not the disability. So these steps are not in order. So it's common sense conversation. Must be timely and documented. And then you always want to consult with the employee to identify any job-related limitations that they may have as a result of a disability. Ask the employee for documentation of their functional limitations from the medical provider. You're not the one going to the medical provider. The employee is. So I would say even though the limitations may be obvious, I would ask for something from the medical provider if you feel that it's necessary. Then identify the essential and non-essential functions of the job with the employee so the employee understands and they can give you a good response. Consult with the employee and HR. These are for your managers, so that they can possibly identify the accommodations, research possible accommodations, and discuss the options. Consult with HR for assistance. So you want to train your management and your supervisory team whenever they get a request like this to please include HR. And it's important because you need to document. Then implement the accommodation that is most appropriate for both the employee and the employer. A reasonable accommodation is a formula, so it's not just reasonable in somebody's mind. This is disparate impact claims regarding pregnancy, childbirth, or related medical conditions. Failure to provide reasonable workplace accommodations to employees affected by such conditions when such conditions are provided to other workers in similar positions can be considered discrimination. So you want to make sure that you cover this base well. Denying an alternative job assignment, modified duties, or other accommodations to a pregnant employee who is temporarily unable to perform some job duties because of pregnancy, childbirth, or a medical condition is sex discrimination when such assignments, modifications, or other accommodations are provided or are required to be provided by a contractor's policy or other relevant laws to other employees whose abilities to perform some of their job duties are similarly affected. So I'm sorry for reading slides to you, but I think that this one it's a complicated paragraph, and I want to make sure that you understand. Use of criminal background checks is another area that the OFCCP has been asking about, and this can result in adverse impact. It's the reason why we're bringing it up here. So if the compliance officer asks if the company has turned down employment based on a background check, they're going to want documentation. Item 21 of the audit letter of the itemized listing of an OFCCP audit asks for your most recent assessment of your personnel processes. Criminal background checks are considered a personal process. On the bottom, we can see that they listed two codes of federal regulations, 6300 and 6741. 300 are for disabled vets, 741 are for disabled. So we know exactly where they're going here, as they're looking for any barriers against any individual with disability not being able to be successful in being hired for a job. You all know about ban the box. Does your employment application ask, have you ever been convicted of a felony? So most of you are on states where you have already removed this question from your application. If you have not, we recommend that you remove this question from your employment application. This will assist in managing multi-state and city regulations for the larger companies. You want to check your state laws if you have only one site and you're not sure if you fall under the ban the box regulation. So check your state laws. You'll gather this information as a result of the pre-employment criminal background check. So people say, well, can we still do a criminal background check? It's applicable to our company, etc. Yes, you can. You do it post-offer, pre-employment. So you extend the offer and then you do the criminal background check. And we do have some companies where they have particular stipulations in their contract with the government where a criminal background check must be done. So remember, you do them post-offer, pre-hire. OFCCP compliance officers are asking if the company includes pre-employment testing of any kind. So you need to statistically validate your employment test. You must provide all applicable information regarding test validation procedure, including the development of the procedure, validity studies, consideration given to alternative selection criteria, and reasons for rejection. So this can be a selection criteria that could result in adverse impact against females, minorities, disabled, or vets. So you want to apply your test uniformly. Give it to everyone that applies for that particular job. Be consistent with, it must be consistent with business necessities, and it must be validated as job related. So we have an example at the bottom of Comcast giving a test that was not uniformly applying to their process and lack of test validation. There are test validation companies that professionally do this, and they can help you with that. So if you are giving a pre-employment test, have your test validated. Make sure it will stand up in court. So the penalties for noncompliance under the OFCCP can range from a technical violation, which does not carry a fine, but it does carry, usually will ask you to enter into a conciliation agreement and resolve the violation with a remedy that is agreed upon by the OFCCP. The next stage would be a notice of discrimination, where they would ask you to enter into a conciliation agreement which would involve fines, penalties, back payment, as well as resolution to the remedies. The next one would be what's called a show cause notice. This is where the OFCCP escalates your violation to Washington, D.C., and then eventually they can debar you from federal contracts. So it is important that you are in compliance. If you are found that you have a violation, and you can have your attorneys fight the violation, but Bank of America lost, Boeing lost, FedEx lost. So if they lose, then they're big, powerful attorneys, you want to be really careful about fighting OFCCP unless you absolutely know that your data is right and theirs is not. So you want to be really careful. This is the opinion of the former director of the OFCCP. And she said, in these cases where we find egregious violations of the law and cannot come to a mutually agreeable resolution, we go to court and we almost always win. In the courtroom, we not only seek out remedies, but we also ask to debar bad actors from being federal contractors any further. This is a step we rarely take, but it is important to note that debarment is a powerful tool that OFCCP can wield to ensure employers comply in the law. So when you go down to the bottom, you can see the address. I gave you the email or the web address of this particular speech. So we encourage you to be proactive. The number one thing that you can do in order to not have adverse impact is train your managers to make employment decisions that are based truly on the person's performance. Make sure that you're hiring the most qualified individual. Make sure that you are promoting according to the person's performance, as well as maybe they have a plan in place where you're progressing with them, or maybe it's somebody that's in training. You want to work with it, make sure you've documented everything, and make sure your hiring managers and your decision makers are making decisions correctly. If you're terminating, make sure you document well. Be consistent in your termination policy. When you're compensating, and we will talk about compensation in our pay equity webinar because that's a whole other area, but when you are selecting someone for compensation, you need to be really careful and be consistent so that you cannot be shown to be with an indicator of discrimination. Document well, keep your backup documentation, conduct self-audits, conduct outreach assessment, and that we will talk about the outreach assessment tomorrow in our applicant tracking webinar. Make sure you have a compensation program in place. You don't necessarily have to have a written policy, but have a program in place that your managers follow, and communicate clearly with your managers. Conduct employee opinion surveys. If you are a member of employers group, you have a free annual employee opinion survey. So we encourage you to take advantage of this member benefit. So if you want to know more about that, you contact Service One and they can make sure that someone communicates with you. I know that some companies don't like to do employee opinion surveys because they're a lot of work because you have to follow up. But that is one way to find out what your employees really feel. Okay, thank you everyone, and we'll leave the line open for questions for a minute. We're going to hang up the audio, and we look forward to having you on tomorrow's webinar for applicant tracking.